Hello, everybody. We're here today. I'm Chris Martin. I'm with Lindsay Kenney, and we're going to talk about buying or selling a business. I have with me Chad Gerson. Chad's just recently become a partner at Lindsay Kenney, but he's been practicing law for over 15 years. He's practiced law in the United States, done some work in China. He's a solicitor. He's well-versed in that type of work, mergers, acquisitions, buying and selling businesses, real estate deals. From my perspective, we call them the pencil pushers who work with businesses and accountants to perfect commercial transactions. I, on the other hand, have been with Lindsay Kenney for 20 years. I'm a litigator. I have extensive experience in all types of litigation, but I do shareholders disputes, employment law, and that takes up a bunch of my practice. So I can offer some insight at the end of this webinar on some employment issues that should be canvassed when you're either selling your business or buying it. And just a couple of technical matters here is that we're not going to take questions during the presentation. We don't think this is going to be long, perhaps with the two of us, 45 minutes. But there's at the top of your menu there should be a Q&A button where you could, if you wanted to ask a question, just identify yourself. You could put the question there if you wanted, but if you say I have a question, I will come back to you at the end of the presentation, or you could just put it in the chat area and just type that in as well. So with that sort of robust intro, I'm going to pass it over to Chad to discuss buying and selling a business from the solicitor side.
Thank you very much, Chris. As Chris mentioned, my name is Chad Gerson. I'm been a partner with Lindsay Kenney for about a year now, and I'm on the solicitor side, mostly focusing on merger and acquisition. I'm the head of our business law practice group. So let's get right on into buying or selling a business. What to consider when buying or selling a business. Slide, please. Okay, so the first fundamental question is, what kind of a deal is it going to be? There are, for the most part, two different kinds of merger and acquisition deals that you most commonly see in the private space, a transfer of shares or a transfer of assets. A transfer of shares means that you buy the whole company. You become the owner of the company rather than the seller. And what you're buying there is a box. Just like on Let's Make a Deal, you're buying the box with everything. You're buying the company's entire history, its balance sheet, its existing contracts, including leases, franchises, employment contracts, and any other relationships that the company may have. Now, it is possible to make a deal to alter the balance sheet somewhat in preparation for the transaction. We'll get into that just a little bit later. And when it comes to leases, franchises, and certain other agreements, there's always a third party, such as the landlord, franchisor, or whoever the third party may be, who may have the right to approve or will at least want to be involved and consent to the transaction. Slide, please. Now, what are some pros of a share purchase for the buyer? Often, you have a quicker transition with less admin work. You just need to transfer the shares of the company after you get an agreement made and signed and you're ready to close. You just transfer the shares over. There's usually no tax on that. Now, bear in mind, I'm not an accountant, but I've done this thousands of times, it seems, and normally you will not pay any tax on the purchaser will not pay any tax on the transfer of the shares. You don't usually need to change contracts, so pending the approval of the landlord, you can usually just take on the existing lease. Pending the approval of the franchisor, you can just take on an existing franchise agreement if it is a franchise business. And you have the relationships, whether they're established by written contract or not, you have your relationship with your employees intact. It may be possible also in some circumstances to leverage the business's existing history and credit, but that is at the discretion, of course, of the banks. Now, there are some cons of a share purchase if you're the buyer. When you inherit the history of the company, you inherit the history of the company, and that includes the history with CRA. So, for example, if you purchase a company and then CRA comes to you and says, this company's tax return from 3 years ago is incorrect, and you owe us more money. From CRA's perspective, it doesn't matter that the company has a new owner. The company is the company, and that's for you to deal with. Now, there are ways to mitigate that risk, which we'll get into a little bit later. Another con of a share purchase is that you may not like the existing balance sheet exactly as it is. So you need to work with the buyer and make an agreement before the closing to possibly to change the balance sheet. You may want the seller to pay off some of the liabilities, or you may want to let some additional working capital accumulate in the company, so on. And the last major con is that you may lose the ability to take advantage of depreciation. Again, that will be between the buyer and their accountant, but typically it's not possible to use depreciation in a share purchase. Slide, please. Now, sellers love share purchases. The biggest reason is because of the capital gains exemption. Most of you are probably familiar with this, but you have a lifetime capital gains exemption, and when you sell capital property like shares in a company, a certain amount of it, your capital gain, the profit that you make, you should be able to take tax-free. That's, of course, again, between you and your accountant, and the limit goes up over time. This is a huge motivation for sellers to sell by a share transfer because you can't do it. You can't take advantage of it when you're selling assets. And it's not always available. You and your accountant would need to discuss, as a seller, you and your accountant would need to discuss whether the capital gains exemption is available for the company that you are selling. The other good thing about it for a seller is that you're not left with an existing company that you have to figure out what to do with. If you sell the assets, you'll have the proceeds of the sale will be in the company, and then you and your accountant need to figure out what to do with the proceeds of the sale. Usually that means how to get them out of the company in a manner that's tax advantaged and eventually wind down the company. So it gives you a little bit more of a clean break as a seller. Slide, please. Now, for an asset purchase, what you're buying is the things that are in the box. So you're unpacking the box and you are taking things out. It's possible to purchase the assets, you might say a la carte. You can specify which assets to buy. Now, most of the time, a business needs all or almost all of its assets to operate. So you're probably buying most of the assets of the company. But there are situations where you might not need particular assets of the company, or where the seller wants to keep particular assets, especially if, for example, a personal use vehicle is commonly an asset that is not transferred over. So you buy the assets that are used to run the business, like equipment, and so on, out of the company. It's also possible to assume liabilities. Now, normally a buyer doesn't want to assume liabilities, but there are situations where it makes sense for the buyer to assume liabilities. If they are ongoing, ordinary course of business trade liabilities, there might be some liabilities that it's reasonable to assume. And also, assuming liabilities is one way to reduce the amount of the purchase price that you need to pay in cash. You can agree on a purchase price and then agree that a portion of it will be paid by assuming liabilities rather than paying cash. Slide, please. Now, for a buyer, what are the pros and cons for a buyer? Here's a picture of somebody who's just purchased a lot of assets. The pros of an asset purchase for the buyer is if there are assets that you don't want, you can leave them behind. You can pick and choose the assets that you want. You don't inherit the full history of the company. You don't inherit the balance sheet of the company. So you sort of start with a clean slate. And often, with the assistance of your accountant, you can take advantage of depreciation. You can depreciate the purchase price of the assets over time for tax savings. Now, there can be some cons of an asset purchase for the buyer. There could be more admin work involved in an asset purchase. So, for example, if you're purchasing a company, I once worked on a deal where the assets being purchased were a bunch of forklifts, trailers, trucks, and things like that, and they were all registered with ICBC, and there were, I don't know, 70 or 80 of them, and every single one of them, of course, had to be re-registered with ICBC under the new owner. So it's possible that there's more admin work involved. And the other thing that creates more admin work is that the relationships that the company had with third parties, contracts with third parties, a lease with the landlord, if there is one, need to be assigned over to the purchaser because it's a different entity now that's going to be operating the business. And you also need to transition the employee relationships. Whether they are by written contract or not, the employees will need to be terminated from the former owner, and you need to hire them on as your employees if you're the buyer. The last potential con for an asset purchase, and it depends on exactly the nature of the assets being transferred, is that PST will apply and other taxes may apply. For example, if real property is involved, the property transfer tax will apply. GST normally does not apply to the sale of a business, but the buyer and the seller need to file an election with CRA to make sure that GST doesn't apply. Slide, please. Now, normally, a buyer will prefer an asset transaction, seller will prefer a share transaction, but there are some situations where a seller might prefer an asset purchase in some circumstances. So, and this is real. Suppose that you own a candy cane making company and your kale flavored candy cane division is not doing so well, and you want to focus on the more traditional flavors like the peppermint candy canes. So you want to sell your kale flavored candy cane production line to somebody else, but you're going to keep running the business with the rest of your assets in your own company. So your company is going to continue to do business. That's a situation where you probably just want to get rid of the assets that you don't need, sell that portion of the business that you don't need, and keep the company. Another example is I had a client sell their business but they had a retail division and a wholesale division, and they were only selling the wholesale division. So it makes sense to keep the same company, sell only what's needed for the wholesale division, and keep the retail division operating in the same company. Another situation where the seller might prefer an asset purchase is if that business is not eligible for the capital gains exemption, or that person may have already used their capital gains exemption from a previous business sale. Slide, please. Now, once you've decided what the structure of the transaction is going to be, the buyer will engage in some due diligence and the seller needs to cooperate in the due diligence. Excuse me. What is due diligence? Due diligence is a series of investigations that your lawyer will assist you with if you're the buyer. And due diligence helps you uncover things like the business's status with the government. You can check to make sure they've paid all their taxes, including their employee withholding and GST, because those are big ones, and their corporate taxes. You can find out whether they have any cases outstanding with employment standards, whether they have any WorkSafe claims pending, and if they're in a regulated business, you can find out the status of their specialty licensing. So businesses in the healthcare field, alcohol, cannabis, engineering, timber, there are lots of different kinds of businesses that require special licensing, and you can find out the status of all of those things. You can also find out whether there are any potential claims against the business's assets. So, excuse me, for example, you can find out whether the assets of the business have been pledged as security, either publicly to a financial institution or privately to a private lender. And that is important whether you're buying the assets or the shares, because if you're buying the shares, the assets are within the company. So you still need to know whether they're pledged for any security. If there's real property involved, you can find out if there are mortgages and other liens or other unusual registrations against the property that might restrict the use of the property. Whether the land is in the agricultural land reserve, for example. You can figure out whether the business is in insolvency or whether it's involved in any litigation. These things are very important because, for example, if you buy a company that's involved in litigation, then the result of the litigation is going to fall to you. You don't want to buy a company that has just been sued for millions of dollars. You can find out whether there are any environmental issues with real property. And in businesses where the branding or other intellectual property is important, you can discover the status of the intellectual property. Slide, please. Now, once you've done your due diligence and you think everything is okay, it's time to get an agreement, a contract in writing. It's very important to be very particular and specific about exactly what you're agreeing to, because if anything happens to go wrong, people will look to the wording of the contract to figure out exactly how they can solve the problem and potentially what they can get away with. So this person here in the picture has technically complied with the no parking sign, but obviously has not complied with the spirit of the no parking sign. Now, what's in an agreement? Most of a contract is about the what ifs and the worst case scenarios. So a contract will contain representations and warranties, conditions, security, possibly security, dispute resolution mechanism usually, and there may be some ancillary agreements that go along with the main purchase and sale agreement. Slide, please. Representations and warranties. What are these? Representations and warranties are a series of statements of fact. Both parties give representations and warranties, but the seller gives many more. The reason for this is the seller has been operating the business, is familiar with the business, knows the business, and the buyer, despite having done some due diligence and probably being familiar with the business, doesn't know the business as intimately as the seller does. So the seller is making a series of statements of fact called representations and warranties, and the buyer is relying on them. Representations and warranties give the other party assurance that there are no hidden surprises. And the purpose of making these statements of fact is that if a representation and warranty is untrue, it could give rise to a claim for losses. So for example, if the seller gives a representation and warranty that they have paid all their taxes, but surprise, surprise, there's an outstanding tax bill that you receive after you buy the company, that means that that would be a breach of the representation and warranty. The representation and warranty is untrue, and it would allow the buyer to make a claim against the seller to recover their losses. Slide, please. Conditions. Conditions are very important. Conditions are a checklist of to-dos before closing. Okay, so usually the buyer and the seller make an agreement, but the agreement, the closing of the transaction is subject to certain conditions. If there's a lease and the buyer is going to take over the lease, one condition would be that the closing is subject to the approval of the landlord. If the landlord doesn't approve the buyer as a tenant in the space, then you can't very well go in and start operating the business. If the buyer is obtaining financing from a chartered bank, for example, for this transaction and won't have the money to complete the purchase unless they get a loan from the bank, then one of the conditions would be that the bank actually approves the loan and forwards the money for the purchase. Usually there are more conditions for the buyer's benefit, but there can be conditions for the seller's benefit as well. And if any of the conditions can't be fulfilled, the transaction may not close. There are a number of different things you can do if a condition isn't fulfilled. Sometimes you can just extend the closing date. Sometimes you can work on figuring a way out around it and amending the agreement. Sometimes the person who has the benefit of the condition might simply decide not to close the transaction and terminate the agreement. So the examples I've given, conditions usually relate to items that are entirely or partially outside of the party's control. You have to have the bank on board, you have to have the landlord on board, you have to have the franchisor on board, and so on. Slide, please. Security. A security is backup for a party in the event of a loss. Here's a clip from the movie Casino where Ace is stuffing all his secret get out of trouble money into the safe deposit box. Security is backup for a party in the event of a loss. So what does that mean? It can benefit the buyer in the form of a holdback. And what that means is that not all of the purchase money is paid up front. There's an amount held in reserve, usually held in trust by a lawyer. And just in case the buyer needs to make any claims against the seller for breach of representations and warranties, they can take that money out of the holdback. That it's easier than giving all the money up front and then trying to get money back from the seller later. And the holdback period, if there is one, can vary, sometimes as short as a month, sometimes as long as a year. But usually security benefits the seller. This comes into play in situations where the buyer pays over time and doesn't pay everything up front. So there's different forms of security. You can do a share pledge or escrow, an asset pledge, mortgage, or personal guarantee. Slide, please. The holdback, as I mentioned, part of the purchase price is held in escrow. If the buyer establishes a claim for the breach of representations and warranties, it can be repaid out of the holdback. Now, a holdback can also be used to adjust the balance sheet. So, for example, suppose that the buyer and the seller have agreed on what the balance sheet is going to look like at the time of closing. But for whatever reason, maybe they made more or fewer sales, or they had some unexpected expenses, something like that. The balance sheet looks a little bit different than they had anticipated it would look like at closing. It's possible to use the holdback to adjust the purchase price either in favor of the buyer or in favor of the seller in order to account for that difference between the actual balance sheet at closing and the expected balance sheet at closing. It can also be used to adjust accounts receivable. So sometimes you have some accounts receivable that you're not sure if you can collect, and the seller is going to try his or her best to collect the accounts receivable, but you can't collect 100% of them all the time. So sometimes that holdback is used to adjust the purchase price to account for bad AR. Slide, please. Now, a share pledge or an escrow. This is sort of like a kid knowing what his Christmas present is going to be because he looked ahead of time, but he's not going to actually have it until Christmas. So what a share pledge does is the shares of a company that are being purchased are held in escrow, usually by an escrow agent under an escrow agreement. And then if the buyer defaults on payment, then some or all of the shares would revert back to the seller instead of receiving the money. Now, the seller would normally have an opportunity to object, or either party really would have the opportunity to object to a transfer of shares out of escrow, depending on the situation. So nobody can just go to the escrow agent and say, oh, this person didn't pay, or hey, I've fully paid up. You have to, normally it would take a statutory declaration, and the other party would either confirm or have an opportunity to object. Slide, please. Now, this is much more common, an asset pledge, otherwise known as collateral. Usually not as exciting as that movie was. What an asset pledge is, an asset pledge happens every day. If you have a bank loan or a line of credit and a business, you probably have pledged your assets as collateral for that loan. But you can also pledge your assets to anybody who's a creditor or a potential creditor, including the seller of a business. So the seller would take security over the assets and register that security. And if the buyer doesn't pay, the seller would be able to take back the assets. An asset pledge doesn't only have to be used in an asset purchase. It can be used in a share purchase too. So I'll take the assets back, but I don't want the company back in the event that the buyer defaults. If the buyer fails to pay, the seller can enforce and take back the assets. Now, just because the seller takes back the assets doesn't mean that the seller is forced back into the business. It's always possible to sell the assets to recoup the loss of the buyer not paying. It's also possible to pledge unrelated assets. So if you have a piece of property or you have some other kind of assets, you can always put up some asset that's outside of the business as security. And this is also commonly done with banks, but it can be done with private parties, just the same as it can be done with banks. Slide, please. A mortgage, everybody's familiar with this. A mortgage, you put up a piece of real property as collateral for the debt. So the real property is security. Mortgage is registered with the land title assets. If the buyer fails to pay, the seller can foreclose on real property and sell that real property. Now, it's also possible to pledge unrelated property, just the way that it's possible to pledge unrelated assets. There have been buyers who, sort of in a pinch, when there wasn't any other security available, pledged their private home as security. Perhaps not the best idea, but it is certainly possible to do. Slide, please. Now, a personal guarantee. If you remember the movie Tommy Boy, you remember that one of the issues was the lack of a guarantee printed on the box for the brake pads. Classic comedy. If you haven't seen it, you should. Personal guarantee. What's a personal guarantee? A personal guarantee is where the buyer or a related party, sometimes both, agree to share the buyer's obligations as if it were their own obligation. So suppose that the buyer of the business has other businesses, other companies, other interests, or suppose that the buyer of the business has family members who are willing to give personal guarantees. The other business, which would normally be a corporation or other individuals, they agree to take on the buyer's obligation as if it were their own. That way, if the buyer fails to pay, the seller can collect from anybody who's given a personal guarantee. Can be individual or corporate, as I mentioned, including third party. But a personal guarantee, although it's valuable, a personal guarantee is only a promise to pay. So it's best to back up the personal guarantee with another form of security, one of the forms that we've already discussed. So if a third party, an individual, or another business that's run in another corporation gives a guarantee of the purchase price, that company can put up its assets or its real property as or even a pledge of its shares as security. Slide, please. Now, usually there's a dispute resolution mechanism in a sale and purchase agreement. These two gentlemen, famous gentlemen, are resolving a dispute. I don't suggest that you resolve your disputes this way. We can write into the contract other dispute resolution mechanisms. Now, the default is court. If there's nothing written into the agreement about dispute resolution, the default is that anybody can sue anybody. And in fact, it's always possible to sue somebody. As long as paper will absorb ink, it's always possible to sue somebody. But it's often to the advantage of both parties to write a dispute resolution mechanism into the agreement. And what that looks like usually is that the parties agree that they should try and negotiate and work out their problems on their own for a certain period of time. Sometimes it's 10 days, sometimes it's a month, sometimes it's even longer. 15 days to a month is pretty standard, and it's that sweet spot where you have enough time to talk, so you don't feel a huge amount of pressure, but it doesn't drag on forever. If you're not able to resolve it by yourself, optionally, you could go to mediation. Mediation is a voluntary process where somebody who's trained to help people resolve their disputes, a mediator, will sit the parties down and try to help them come to an agreed voluntary solution. Now, that's certainly not mandatory, but sometimes a dispute resolution mechanism will include that if the parties would like to try and resolve things among themselves. A popular option is arbitration. Arbitration is like private court. There's an arbitrator, a person who's trained to resolve these disputes, and the parties would make a case to the arbitrator just like they would make a case to court, and the arbitrator would issue a decision just like the judge would issue a decision. The advantage is that you can usually get it done much faster than court, and you can usually get it done much cheaper than court. But there are disadvantages. Often you will not be able to appeal an arbitration decision, and sometimes some studies have shown that arbitration is it usually favors the buyers, but that's not necessarily the case. Every case is different. It depends on the fact pattern there. But it's important to have a dispute resolution, because otherwise there's no way to resolve it except in court. Slide, please. Coming to the end of my portion of the presentation. Now, ancillary agreements, these are agreements that are on the side, and they're usually signed along with the purchase and sale agreement, because the parties may have other needs. So one of the things that a buyer might want is for the seller to continue on with the business for a while as an employee, to provide what we usually call transition services or continued employment. This is particularly important in relationship-based businesses, where the seller would be expected to spend some time transitioning those close relationships to the buyer. Another popular one is a non-competition agreement. So if the buyer is buying a business and expects it to do well, you don't want the seller opening up the same kind of business next door and competing with the business that he or she just sold. So usually we have a non-competition agreement. How long you can restrict a person from competing with you and the exact circumstances depends somewhat on the fact pattern. But usually you can enforce between 2 to 5 years and within a reasonable radius of the existing business. A lease. Now, there are some situations where a person has been operating a business on land that they own, so they don't need a lease. And the buyer is going to be continuing the business at that location. They're going to buy the business, but they're not going to buy the land. So then you would want to have a lease agreement in place between the buyer as tenant and the seller as landlord. That's a fairly common arrangement, and negotiating the lease is important. It's important to negotiate these ancillary agreements at the time when the purchase and sale agreement is negotiated, because you want the relationship between the parties clearly defined. You don't want to make one agreement and then have some uncertainty about things like the lease. And there could be other ongoing relationships between the buyer and seller. So I used the example of a client of mine who kept her retail division, but sold her wholesale division. But part of the attraction of the wholesale division was that it sold product into the retail division. So the buyer, who was now running the wholesale operation, and the seller was now who kept the retail operation, formed a contract between themselves where the retail operation, the seller, guaranteed a certain level of purchases from the wholesale division for the first several years after the closing of the sale, because a lot of that, the wholesale division's business was selling into the retail division. So that was a guarantee that the wholesale division would continue to prosper. And of course, the wholesale division had other customers and was free to find other customers, but that gave the buyer some confidence that that part of the business wasn't going to dry up. So there could be any number of other relationships that the parties might have after the closing of the contract for purchase and sale. So all of these things that I've discussed, that's really a brief overview of all the things you need to consider when you're buying or selling a business. It is very important that you come talk to us and also have a good accountant because you can't leave these things to chance, and you need agreements that are really going to reflect the deal that you want to make and aren't going to get you into trouble later. So thank you very much. I'd like to pass it over to Chris Martin to discuss the employment aspects.
Thanks, Chad. Just before I'm sort of batting cleanup here, before I move on, Chad, and it touches upon the employment circumstances of buying and selling a business, is this notion of non-competition. And there's a distinction that everybody should keep in mind. When you're a vendor of a business, that's distinct as an employee of a business. And then sometimes there's a vendor who happens to be the employee of the business and a key employee that you're going to retain. And why I say the distinction, there is a distinction, and it's something you should turn your mind to, is that a vendor gets paid, hopefully very well, for their business. And it makes sense that they shouldn't take $1 million and then open up a shop right beside you and compete for the money that you've paid for that. But with an employee, the issue is, well, you can't stop an employee, for instance, from what they're trained to do, and they should be free in the marketplace to offer their services. This isn't a notion where they're tied to their employer for in perpetuity. So in an employment relationship, you look at more of a non-solicitation, confidentiality issues when you're formulating agreements, because it's permissible for them not to use information they've obtained in the course of the employment to compete unfairly, versus precluding that employee from doing what they're trained to do, whether they're an engineer, a skilled mechanic. Those types of non-competitions to employees will be and sometimes struck down. But when you sell your business, the courts have said, well, there's a recognition you won't compete down the street if the contract expressly says that. Besides that, the issue arises when you're buying or selling a business, which I've seen when clients come to see me, is one is a vendor is getting ready to shut down a long-term organization and or sell it, and they're really concerned about what's going to happen to my employees. They've been with them for 20, 30 years, and what are the options for me to maximize my retirement, selling the business and ensuring future employment for my employees. And so from a purchaser's perspective, employees are often looked as integral to the business as just acquiring the assets. They are the key players in making the business profitable. So it's a dance between the liabilities employees can be and the assets that they are. And for any prospective purchaser or seller, you just have to look at the basic claims an employee can make when you're assessing your liabilities that Chad walked you through. Doing your due diligence is employees are entitled to all rights under the Employment Standards Act, which sets out the minimum requirements when a relationship is terminated. But the more important one is the common law requirements that are set out in if an employee is terminated, they're entitled to notice. So under the Employment Standards Act, it's a statutory minimum of a week per year of service to a maximum of 8. Under the common law, it can be quite larger. Basically, it's based on 4 factors: an employee's age, their length of service, the nature of the position in the organization, general manager, CEO. The higher position, the harder it's going to replace that employment. And so they look at that, and they look at the chances of finding work in the marketplace. The rough rule of thumb is that an employee is entitled to essentially a month per year of service. So you can see where the liabilities can come in a hurry for a potential vendor of a business if you're terminating these relationships, or a purchaser of a business if you're accepting them. If you have an employee that is making $100,000 a year, they've been working for you for 30 years, the maximum notice they could get possibly is 2 years' pay. That's about $200,000 that you're taking on and it may be worth taking on because of the value of the employee, but that's the type of consideration you should take into place. Now, employment agreements can limit the amount of notice or pay in lieu of notice, but those have to be carefully inspected. So if there are employment agreements in place, and any enterprising solicitor like Chad is would be saying, yes, we want to see those, because it's not good enough to tell me, okay, I've got an employment agreement and it limits severance pay or pay in lieu of notice to 3 months or 12 months or whatever they're saying. You have to ensure that that clause, because it's a limitation of liability clause, is carefully drafted and wouldn't be struck down by a court. So the other liability, other than pay for severance pay or termination pay, is employees that are on disability leave or on maternity leave or any sort of compassion leave. Employees on leave have to be protected under the Human Rights Code, and their continuation of employment after the sale or their termination at the time of sale has to be carefully viewed to ensure that you don't violate the terms of the Human Rights Code and open yourself to a claim for damages, or in some instances under the Human Rights Code, it could be reinstatement for the employee. So from the vendor and the purchaser, they're looking at both those perspectives. So they need to have a long review of the workforce, how old, the length of service, the remuneration. They need to know who's on leave, what type of leave it is, when their expected return to work is, ensuring that when you're sharing that information, the confidentiality of medical records and medical status is respected. So those are the types of things that are a consideration from the employment perspective, and most solicitors, I know Chad is always dealing with that, and then dealing with our employment group on what aspects you can or what avenues can be explored to mitigate that loss, or create a structure that's both encouraging to the employee and the employers, or the past employer, the new employer. So as Chad talked, the two principal things are a share sale and an asset sale. And I'm seeing my slides, and I think we're a little behind here, but what I'm moving on to is the structure of the sale. And what I think should be taken from this afternoon is it doesn't matter from, or it does matter from, a share sale, as Chad says, is the enterprise continues as it is, and there is no break in service. There is no new employer. An asset sale, in theory, is a break of that. So if I was employed by the vendor and it was an asset sale of our trucks, as Chad mentioned, to a new enterprise, well, then in theory, if I was offered employment from the new enterprise, it would be a new arrangement. And if that was the case, then long-serving employees would be out of luck, in that one of the major factors taken into account for pay in lieu of notice or severance pay is your service to the employer. So in that theory, what would occur is I work for 20 years, my employer sells its assets, the purchaser then offers me employment to use those assets, and I would have given up my service with the new employer, where there would be a break, old employer, new employer. A new employer could say, well, you can sue me for wrongful dismissal, but you only have the time from the purchase and sale agreement to count for service, and that's one of the quantification of damages. The courts have said, well, no, that's not exactly the case. They know that often asset sales are structured, as Chad said, because of other considerations, including balance sheet considerations, including new enterprise, including liabilities, including tax consequences of the sale. So they've said, well, look, what is really going on here is this business a going concern is the test that they've looked at, and whether the going concern has broken. And so my point being that even in an asset sale, if the purchaser intends on acquiring the assets and then hiring the employees, the same considerations have to be made about, okay, what are we doing and who's bearing the responsibility of the liability of employee service and future claims for wrongful dismissal. Where we're at in our slides, whoever's doing the slides, I think it's Kathleen, is we're quite a ways forward here. If you want to skip. Okay, let's just stop there. For instance, what we're talking about at common law is Section 97 in the Employment Standards Act basically summarizes my summary of a few minutes ago. It says basically if all or part of the business or a substantial part of the entire assets of a business is disposed of, the employment of an employee of the business is deemed for the purposes of this act to be continuous and uninterrupted by the disposition. So if there is no break in the relationship with the vendor and then to the new employer, the Employment Standards Act continues. How can that occur? Well, the vendor could give notice to all of its employees at a date certain that their employment will be terminated, a date before the purchase. And that would be a simple way to sever all those relationships. The vendor would be responsible. The claims made against the vendor would be the responsibility of the vendor. But the reality of that is that it doesn't occur because the purchaser wants to carry on with some of these employees and then will offer them new employment at the date of purchase. The key distinction when offering new employment is that an employee has a duty to mitigate its loss and should accept new employment if it's on the same terms and conditions of what was in place prior. And one of those conditions is my service. So if the new employer offers, the purchaser, new employer offers a contract to the serviced employer of the vendor and says, I'm recognizing all past service with vendor, no issue. If a new purchaser doesn't recognize that service or expressly excludes that service, there is an issue for both the vendor in that the employee can say, look, that wasn't an offer that truly mitigated my loss. I was giving up something, and sue the vendor. Or if the new offer of employment is silent on service, it will be deemed service. It will say, look, you offered this to the employee, the going concern is the same, and you've now accepted the 20 years that the employee worked with the vendor. So the provision in the Employment Standards Act illustrates really what the courts will do in circumstances where there has been a change of ownership or assets, and an employee then continues on with the successor purchaser, and 3 or 4 years down the road, there's a wrongful dismissal or without cause dismissal, and there's a difference of opinion. The purchaser says, well, you've only worked for me for 2 years. And the employee says, well, that is correct, but I also worked 20 years doing exactly the same. So my claim isn't 2 or 3 months, it's 20 to 24 months. So that's the real key consideration when looking at that. And then, of course, Chad, as he advised earlier, is when you're looking at acquiring the assets or terminating employees from the vendor's perspective, is it's important to consider those that are on leave. In particular, if winding up the business would affect the employee who's on disability leaves entitlement to insurance or entitlement to the care that they're getting, because those loss of disability claims can be quite severe in that some employees, young employees, never return back to work. So that's why those have to be canvassed. But that is really the long and the short of employee aspects. There are a number of ways that those risks can be mitigated. There's a number of ways where you, as a prospective purchaser can retain the employees you want and tell the vendor that they're on the hook for other employees. It isn't a take the whole workforce or not. You can selectively choose which employees you want to maintain. And then, of course, as touched upon by Chad, key employees, you can, and especially employees that are benefiting from the sale, whether they own shares or own assets in the sale, can be tied up to the extent of non-competition, but at the very minimum with non-solicitation and confidentiality provisions that expand on the common law requirements and make it crystal clear what a high-level employee could do down the road after the purchase. So, subject to any questions, that's all I have to say.